Friends, in this video we will be discussing about public interest litigation. As you could see on the screen, public interest litigation in India, and we will try to understand various provisions with respect to PIL in India. And we all know that in constantly it is in news because of various reasons, be it for sake of protecting fundamental rights, clearing the pending cases on politicians, the PILs, protecting the environment. So we'll be discussing about what public interest litigation in this video. As we all know that preamble of India provides summary, a quick overview of Indian Constitution. As you could see on the screen, my dear friends, justice of social, economic, and political is one of the basic philosophies of Indian Constitution. The makers of the Constitution were not sure to provide it as a fundamental right, so that is why they were silent about this. So they mentioned about it in the preamble. So whereas in the post-independence, economic situation got better, so we are in a good position, socially, economic, and politically in so many aspects. So the government of India came up with some amendment to the constitution. In 42nd Amendment Act, as you could see on the screen, they added a new provision to the DPSPs. DPSPs are guidelines for the government to the legislature and executive to keep in mind while formulating policies. So this Article 39A says about free legal aid, and most importantly justice for all the people. What? Equal justice for all the people and free legal aid. This Article 39A tries to bring social justice and affordable justice to the needy sections of the society. Unfortunately, there is no any scheme which says about free legal aid and equal justice, whereas Supreme Court of India came up with some interpretations, and it is called as a public interest litigation. So much of this is inspired from the social action litigation of USC, as you could see on the screen. Social action litigation, which is prevalent in America, so much inspired for the origin of public interest litigation in India. Now we will try to understand the meaning of public interest litigation. So it is like a petition, complaint initiated in a court. What? Initiated in a court, a legal action initiated in a court to seek to protect the interest of what? Public, interest of people. So as you could see on the screen, it tries to promote and protect the interests of the society or interests of the people at large. And most importantly, this the meaning of what is PAL is not defined by a law. It is so much interpreted by the judges of be it Supreme Court and High Court. The genesis of this PIL is to provide and to ensure public good. As you could see on the screen, public good, which means it is common good or well-being of all sections of the society, underprivileged sections, women and children, and ensuring safeguarding the environment. So now we will try to understand why this PIL is needed. First and foremost, we all know that though there is a constitution, though there are certain limitations, though there is a constitutionalism. So to ensure this legal obligations, to put some restrictions upon the actions of the legislature and the executive, and to ensure that rule of law is followed in the day-to-day governance of the country. So now we'll try to understand the constitutional provisions with respect to the PIL. The first and foremost question is it mentioned in the constitution? The answer is no, it is not mentioned in the Constitution of India. Then from where this power of PIL is derives? So we all know that there are some rights, fundamental rights which are guaranteed, and one of the right is Article 32, right to constitutional remedies, and these are also called as the 5 writs. To ensure and to enforce these writs, Supreme Court of India exercises through Article 32, and High Courts through Article 226 exercises writ jurisdictory power to ensure safeguarding fundamental rights. And not just that, not just writ jurisdiction of Supreme Court and the High Courts. There is one more provision which provides a path for the PIL in India, that is called judicial review. So if you do not know what is judicial review, I made a video on judicial review. It is available in this channel. So judicial review is simply review by the Supreme Courts and High Courts to legitimize the actions of what legislature and executive and to safeguard the constitution. And most importantly, this PIL, now we will try to understand how it got evolved. Since it is not part of the original constitution, then how it got evolved. So as you could see on the screen, the first instance of the word PIL is used in this case of Justice Krishna Iyer in 1976. So the PIL was coined in this case. However, the first case of PIL was filed in this case, Husainara Cartoon versus State of Bihar 1979. The first PIL case is called as what? 1979 case. Ever since that, there were so many cases with respect to PIL. So there are certain judges or cases which try to give some momentum to the legal aid, to the social justice, and one of those such instances is, as you could see on the screen, Justice P.N. Bhagwati. He in this case of S.P. Gupta versus Union of India, this justice called Bhagwati, he tries to emphasize so much on social justice and the role of PIL. Ever since this case, PIL became very much debated and discussed, and we could see in everyday news also, in everyday Indian government and politics also. This PIL is playing a crucial role in ensuring legal aid and ensuring fundamental rights, ensuring rights of all sections of the society. Now we will try to understand who entertained the cases of PIL. So the answer is Supreme Court and the High Courts of India entertain the cases with respect to PILs in India. And most importantly, who can file a PIL? So who can file this litigation or petition in Supreme Court and High Court? The answer is any publicly spirited individual or organization, any citizen. Here publicly spirited individual means citizen. Only citizens can file PIL, or not just citizens, organizations also can file PIL in the Supreme Court and High Court. And the most important provision here is there should be no personal motive. Well, there should be no personal motive of the petitioner. And most importantly, this PIL is would be filed through Article 32, which is called the jurisdiction of Supreme Court, 226 High Courts, and most importantly, Criminal Procedure Code of Section 133. Under these provisions, any citizen with keeping public interest in mind can file a complaint or litigation in the Supreme Court and High Court. Now we will try to understand against whom these PILs can be filed. So the answer is any public authority, against any public authority, or those who are holding public offices, and most importantly against individuals, against organizations, so which put a threat to the public interest and to the sections of the society. So the answer is it could be filed against, as you could see on the public authority, those who are holding public offices, be it at central level or state level governments, and most importantly against an individual or against organization. The very meaning and scope of PIL says to ensure rights of individual, all sections of the society, and there are certain sections of society who are mostly exploited, like women, like laborers, and like children, and like environment. So in order to ensure well-being of laborers, well-being of women, protection of environment, and heritage sites, and healthy food adulteration, one of the trending thing, and corruption-free society. So these are the major areas where PIL is so much entertained in India. So what will happen when a petitioner files a PIL and the court gives some guidelines, some gives its orders, and it also tries to give compensation to the concerned party, and it also tries to ensure what justice to the concerned party. The outcomes of PIL would be like what? Ensuring justice and compensation, and like court ordering the be it legislative bodies or executive bodies or public authorities. Now let us see the importance of PIL. First and foremost, it brings awareness about rights of the individual, rights of the people, and the protection of these rights of all sections of the society. This PIL brings some sort of discipline among the public officials, among the governmental bodies, be it central government, state level governments, local level governments, panchayat governments, municipality governments. It tries to bring some sort of fear, and there will be greater efficiency and accountability of public officials and governmental agencies. And at large, the aim of this PIL is to ensure what welfare of all sections of the society, well-being, especially legal well-being, and no exploitation of vulnerable sections or weaker sections of the society, be it women, children, laborers, or taking for granted the environment. And one of the greater significance or importance of PIL is less cost-effective court trials and also speedy trials. We all know that there are so many cases are pending in the courts of India, especially in high courts and in lower courts also. Lakhs of cases are pending, and there are some 10 cases with respect to PILs are also pending. Particularly, as you could see on the screen, fundamental rights violation PILs around 3,000 are pending in the Supreme Court as of July 30, 2021. And there are certain PILs against politicians, as you could see on the screen. Around 5,000 cases are pending, PIL pending cases on politicians are pending in India. So this is one of the gray areas or challenges of PILs, like misuse or overuse or abuse of these PILs. How it is misused, we will try to discuss in this video. We will try to understand. And so many say that this is not public interest litigation. It is what? Personal interest litigation, as you could see on the screen. Personal interest litigation, which means selfishly, some politicians, some political parties, for political deeds and gains, they are filing a PIL against politicians, against bodies or organizations. And one of the constant criticism about intervention of judiciary in the actions of executive and executive and legislature is what? Judicial overreach, be it with judicial review, judicial activism, and PILs and court orders. So one of the criticism about or concerns about this PIL is what? So much of criticism on PIL because of judicial overreach and lack of the independence of executive and legislature from judiciary. And as we already saw, disposal of the cases, which means pending cases are so high, not just in normal cases and criminal cases with respect to PILs are also, which is a challenging or concerns for the well-being of all sections of the society. Recent mostly, there is a PIL with respect to Article 32 in the Supreme Court, and this was so much signifies the misuse of this concept of PIL in India. So as you could see on the screen, Supreme Court imposed a fine of 5,000 rupees to the petitioner, and there are so many cases, not just this case, in which the Supreme Court and High Courts are not happy with the petitioners. The real challenge with respect to ensuring legal aid and free legal access and less cost-effective legal aid, social justice, the answer is to make sure that PIL is effective and disposal of cases fastly and quickly. So the way forward for this public interest litigation, as you could see on the screen, is the PIL, the petitioners, they should be responsible and their actions should be accountable. The court should come up with fines, if necessary, with punishment, severe punishments also, to save the valuable times of the courts. Not just that, there should be a specialization in this areas like environment, children, laborers, clean environment, all these areas. There is a need for specialized knowledge to look after the cases of PILs there should be specialized judges and advocates and lawyers with respect to the fundamental rights violation PILs. So there is a need of what? Specialized courts and judges and lawyers and advocates. And not just that, recently in 2021, Supreme Court, what? Supreme Court came up with some certain conditions with respect to filing a petition through PIL, and it is called as a Ashok Kumar versus State of West Bengal. In this case, Supreme Court came up with some certain terms and conditions, certain guidelines for the petitioners to exercise their power or right to file a PIL. So the guidelines outlined in this 2021 that the Supreme Court should be followed, and not just that, there should be a filtration of the cases before the Supreme Court and High Court entertain the PILs, which would ease the burden of the Supreme Court and High Courts. One of the problematic area of PILs is courts are already burdened with so many cases. So many say that this is also a burden on the work of Supreme Court and High Courts. So there should be a more number of courts and more number of judges to look after the pending cases of PILs and other respective cases. And I hope this video helps you to understand PIL, its origin, its meaning, and most importantly, who can file a PIL against whom, and importance of PIL, and most importantly, various gray areas and concern areas of PIL, and we also discussed the way forward of the PIL. And thank you for watching, and we'll come up with a new topic in the next video. And thank you.